Okay, we seem to have quorum, so we can just begin. Good afternoon, everyone, and welcome to today's conversation under the Chartered Institute of Arbitrators, Kenya Branch State of ADR series. Even before I introduce myself, allow me to give apologies from our CEO. She is currently in a different forum, but I'm hoping that she'll come and join us in the course of the conversation. My name is Rono, and I have the pleasure of moderating this timely and necessary conversation on arbitration in the AI and digital age. So we meet at a pivotal moment in the evolution of dispute resolution. This is arbitration, which was once defined by type submissions, in-person hearings, and quiet boardrooms, which is now increasingly shaped by encrypted video calls. I've just seen someone joining as Fireflies AI, so I assume there's something going on there relevant to what I'm talking about, algorithmic analysis and smart legal tools. Artificial intelligence is no longer theoretical, it's assisting with document disclosure, legal research, case predictions, and in some contexts, even shaping arbitral reasoning. But with all this innovation, we must pause and ask, are we truly prepared for the ethical, procedural, and regulatory implications? So allow me to interject at this point and say, when we were having our debrief yesterday with the panelists, who I am introducing shortly, a lot of things came into perspective. We shared that most of us have had instances in which we've tried the LLMs to do various things, but they're not properly equipped. So today we'd like to dive in deeply into this particular conversation and see how to use it properly, the ethical consideration, the regulatory implications, and the like. So can AI support justice without compromising foundational values like neutrality, confidentiality, and party autonomy? And how can we, as a legal arbitral community, ensure that we adopt these technologies responsibly, deliberately, and contextually? So to unpack this question, we are joined by three exceptional thought leaders, fine gentlemen in the profession, each uniquely positioned at the intersection of law, technology, and governance. And together, they bring a 360-degree lens to today's conversation. So first, and I'll request all of them to have their videos on. Nelson, Quincy, please have your videos on. Thank you. And Clement, if you can, when I'm introducing one, please spotlight them so that despite them being named, we know who is who. So first, we have Nelson Nkari. He's an advocate of the High Court of Kenya and a leading voice in the legal, technology, and innovation space. With a professional background in both computer science and law, Nelson brings a deeply technical understanding to how AI tools, such as smart contracts, predictive systems, and legal automation are transforming dispute resolution. He also played an instrumental role in the drafting of Kenya's national AI strategy. Nelson will help us explore how AI is actually being applied in arbitration today, the legal considerations when adopting such tools, and critical issues like admissibility and procedural fairness. Next, joining us to ground the discussion in ethics and policy is Quency Otieno, who's an advocate of the High Court of Kenya, certified secretary, holds a master's from the University of Nairobi on technology law, a certified professional mediator, associate of the Chartered Institute of Arbitrators, and a legal officer at the Kenyan Parliament. He specializes in AI safety and policy and AI governance, currently pursuing his doctorate in technology law, focusing on biometric systems and AI governance, and digital rights specialist. Quincy has also been actively engaged in the development of responsible AI frameworks, data justice, and digital policy. He will help us think through questions around ethical limits, transparency, and the role of regulation, both in Kenya and around the world, and in setting boundaries for AI in dispute resolution. And finally, we're privileged to have Moses Kahoro, who's a senior associate at MG Law, a seasoned data privacy advocate and cybersecurity consultant. Moses bridges law and technical expertise in helping organizations secure their digital systems and comply with data protection laws. He's also involved in complex arbitration disputes. His insights will guide us through risks and safeguards around digital evidence, confidentiality, ethical use of data in arbitration, and how we avoid over-reliance on tools that may compromise fairness or privacy. Now let's dive into the conversation. So discussion today, and I'm sure my panelists are ready by now, will unfold in 4 structured rounds. We will start with the first round, which ideally I've labeled as setting the stage. So to Nelson, I'm sure by now you're ready.
Yes, I am.
Perfect. So from a practitioner's lens, how is AI currently enhancing or disrupting arbitration? What real tools or platforms are you seeing being used? And you can start from the basics. For those who've just joined us and basically have a very rough overview of what artificial intelligence involves, what LLMs are, and they're hearing all these buzzwords, give them a brief analysis of what this is.
Okay, thank you, Nkari, for the introduction. Um, what is artificial intelligence? I think most of us have probably by now interacted with AI systems at different levels. We have ChatGPT that has basically infiltrated most of our professional circles and academic circles. But generally, artificial intelligence is the mimicking, the ability of computer systems to mimic human intelligence. So it's the ability of computer systems to um, reason as humans do, to provide outputs that are grounded on reasoning that is similar to how we operate as human beings. That is basically what artificial intelligence is. It's systems that are trained on large sets of data to provide outputs that are reasoned out, similar to how we reason as human beings. It has different use cases, and it has found different use cases in different professions, including our own legal profession. It's being used for document information, document review, document drafting, and various other decision support operations in the legal workplace. So why do we turn to artificial intelligence? It's because it provides us with efficiency, cost reduction, and allows us to make data-driven decisions. Those are the benefits that AI has so far provided us with, that we are experiencing in the profession, and the reason why we find it entering into the different corners of our profession, such as what we're discussing today with arbitration. But with these problems, with these benefits also comes problems such as neutrality, due process, admissibility of evidence, and something we call algorithmic justice. So it gives with one hand and also takes with the other hand. I like to think of it as a bit like Schrodinger's cat. I don't know how many of us are familiar with that thought experiment. Um, it's basically a thought experiment in quantum mechanics whereby um, there's a hypothetical cat that's been placed in a box with an atomic element, which will release a poison uh, after it decays. And so basically, it's impossible to know whether the cat is alive or dead until you open the box. And so for me, it's the same thing with artificial intelligence. It's difficult for us to know really how much is going to benefit us or how much it's going to be a detriment to the profession unless we get into the nitty-gritties of it and understand and see where it's bringing benefits or where it's being detrimental, and weighing these two things against each other to see really, is it worth it? Is it worth going ahead with this, or is it something we should set aside? So as far as enhancements are concerned, we have document review and analysis. This is where we use natural language processing to extract the relevant information from documents. An example of these systems that do document review include Kira systems or Luminance. Those are examples of real-world examples of AI systems that you can use for document review. We also have online dispute resolution platforms. These are digital tools that are used to facilitate the online resolution of disputes. I have mostly seen this being used to support disputes arising, or rather to help resolve disputes arising from online purchases. A practical example of this is the European Union Online Dispute Resolution Platform, but this was discontinued earlier this year to be replaced by a different system. There's also a system called Smart ADR, and another example is a system called Moderator. So these systems facilitate communication, document exchange, and decision making. There's also the function of document drafting and legal reasoning. An example of such a system is called Harvey AI, which I was shocked to learn was named after Harvey Specter from the TV show Suits. I'm sure most of us have come across that show. especially when we were in law school. And finally, we have decision support systems. These are AI tools that are used to facilitate decision making. They analyze data and provide information to support the choices that are made. So specifically in supporting, for example, decisions behind the arbitral award. So there are different kinds of decision support systems. There are data-driven systems, which primarily rely on data to assist in decision making. There are model or simulation-driven systems. These are reliant mostly on the model or modeling. By modeling, we mean creating simulations based on data and supporting the decision to be arrived at based on the models or simulations. There are knowledge-driven decision support systems, which rely on expert knowledge to support the decision to be made. There are also document-driven decision support systems, which rely on the documents that you share within the dispute resolution process. And then there's also a communication-driven decision support system, which relies on the communications of the parties involved in making the decision to arrive at the decision. So essentially, those are the enhancements that we can expect. And in the next question, we'll get to the problems. We'll dive deeper into the problems, which I mentioned to neutrality, due process admissibility of evidence, and algorithmic justice.
Thank you very much, Nelson, and thank you for setting for us the stage on the basics. So allow me to switch to Quency. So I am seeming to have an accent from this, but globally, how are states and institutions approaching the use of AI in justice systems, and what trajectory are we seeing?
Thank you for that. Confirm that you can hear me.
Clearly, very clearly.
Okay, so world over, we have quite a fragmented front when it comes to application and adoption of AI. Currently, we have a lot of sectorial drivers who are now fronting the utilization of AI in the systems. I'll give you an example. World over, there is a huge fight right now between the intellectual property domain and the artificial intelligence domain. From Nelson's definition or from Nelson's capacity, he does say that there are quite a number of use cases of how the AI learns and how it builds up the information portfolio. However, one of the current rumors or the fear-mongering capacity is that it's here to take away a few liberties which we have. Some of them, per se in particular, when we look at now the legal fraternity or like the alternative dispute fraternity, is the ability for you to influence or to make a decision based on your discretion. There is a lot, or there are three categories of schools of thought currently. One, those who will love to adopt these particular technologies. Two, those who think that it is still novel and you still need a bit of time to adapt to rules. And three, those of us who wholly adopt it. Now, out of these three schools of thought, those who say that it is still novel and we still need to learn have actually fronted studies. And if you look at, since the advent of ChatGPT becoming a downloadable application, you will tend to look at how we've moved from a major LLM system to agentic systems to now people adding what we call RAG coefficients in majority of systems in public service. Those people tend to believe that if we adopt this particular technology per se, it will lead to a reduced turnaround time. Let me give you an example. Currently in government, we have one of the worst document management systems. And the reason why we have terrible document management systems is a lot of records are not found online. When, for example, Parliament did introduce a system mid last year, it helped legal officers and clerks and research officers to fetch and to be able to scrutinize documents more efficiently. This in tandem is with how we tend to churn out reports, do committee issues. Like today we had an arbitration matter here at the commission, and the clerk would fetch that particular disputed document very fast because the RAG system worked very efficiently. I'm sure Nelson would love to break that down for you, how the RAG works. Now, those who say that the system is not yet ready and we are going to fight with it, tend to have the school of thought that we have what we call brain drain and the lack of independent thinking or the lack of independent analysis. This can be seen by Apple, which recently released its paper breaking down or demystifying how a thinking model or deep thinking actually works. And it's just pattern recognition, which breaks down further information into bits, and these bits tend to now solve the tasks according to now smaller decision trees, which makes it easy for the deep learning angle of the AI to solve the tasks. However, it did find that there is no critical thinking in between. And the reason why there's no critical thinking is they took two sets of questions, one to a professor and then one to its internal IT team. And then they got answers which, by human effort, were similar in terms of scope, in terms of answering, and in terms of conclusion, which was well and dandy in tandem with what was expected. When that particular AI system, they didn't mention the particular LLM which was used. When they used the deep search engine, they found that the variance was greater than 38%, which is alarming. Additionally to this, tests were being done earlier this year to Anthropic's model Claude, and they found that it was silently overwriting its code. And the reason why it was alarming is out of 100 tests which were done, the person who's prompting the system, 9 out of 100 times, 9 times the system failed to execute that function. And the function is very simple. Can you shut down your systems and stop learning? And it raised an alarm because, as Nelson and as Moses will put it as we go forward, there is always a fear that if we cannot explain from the word go how this particular system reasons, why it's refusing to execute our command, then there is a fear of in, sentient. And that is something which, on the decision, courts will rely on the Constitution being the ground, and this will be in tandem with a couple of other laws. And since we have like a fragmented framework, it's really important to keep this at the back of your mind. Now, Dr. Rice, who teaches computer science and in tandem works with the health department at Harvard, did say that an increased usage and dependency on artificial intelligence systems, or ADM systems, as it's termed in most academic papers, leads to less firing of synapses in your brain, meaning you won't have the right deep thinking, critical analysis segment in your brain.
Moment to ask a question of our plenary session. So we'll move to our next round, which is basically going to focus on ethics and oversight. So with the integration of AI comes a critical need for clear boundaries. What should machines do and where must human discretion prevail? What does ethical use really means when justice is involved? So along with that, I anticipate you now had a glass of water, cup of coffee, and you are ready. So what considerations should arbitrators or parties keep in mind when selecting AI tools, especially around transparency and reliability? The beautiful thing is Moses already set the stage for this, especially in respect to data protection and the like. So along those ambits that he set, please answer this question.
Okay. So as far as considerations that we need to keep in mind are concerned, I think I previously mentioned some of the challenges with these AI systems to be neutrality, due process, admissibility of evidence, and algorithmic justice. But we also have to make considerations for confidentiality, the speed, of matter resolution or dispute resolution, impartiality, and most importantly, procedural fairness. So especially as regards decision support systems, when you're using artificial intelligence to support or augment the decision-making process, there needs to be explainability and transparency in how these systems arrive at whatever decision they propose. The outputs need to be explainable, and you need to be able to interrogate the rationale behind a decision or a prediction that has been made by these computerized systems. It is also important to have training data resources be properly documented, because with properly documented training data, you are able to interrogate the decision that has been arrived at by the system. Then again, it's also important to use interpretable models or models that have an explainability layer to them. So the explainability layer allows you to interrogate how the system arrived at whatever decision that it recommended to you. Second is reliability and accuracy. This is most important when we're using AI systems to summarize evidence. So we've been given a whole bunch of documents that we want to be able to quickly peruse and get the summary for, and extract perhaps relevant clauses. So for this, we need to select tools that have domain-specific testing. What does that mean? It means that we are selecting tools that are purpose-built. So you're not just going to, for instance, and I'm not saying, I'm not really throwing shade at it, but you're not just going to ChatGPT and telling it to do something that perhaps it's not optimized for. You're selecting a tool that has been built specifically for that purpose. And if you want to know if this tool is good enough for whatever you want it to do, you should test it against a known outcome. So I have a known outcome, I have the inputs that led to that known outcome, I feed them into the AI system, and if it gives me the same outcome, then I have proof that this system is reliable and accurate. Then there's admissibility. This goes to our ability to trace, or rather the tool's ability to trace the origin and the transmission of data. Moses has talked about the chain of custody in some way. Is this tool also forensically verifiable? Is the output that it gives you forensically verifiable? Are you able to get an independent third party to interrogate, to forensically interrogate this tool and the outputs that it has given to you, whether that is through metadata or through digital signatures? Basically, is there embedded data within these outputs that can allow for independent verification of whatever outputs or outcomes that are given to you by the system? Then we have algorithmic justice and bias mitigation, especially where AI systems are trained on historical data. They may replicate or amplify biases. Bias is inherent in data because a lot of the data is collected by human beings, and sometimes our biases seep into the data that we collect. A very good example I like to use is the problem that we have with predictive policing. Though this might not be a problem for us at present, but it's a problem in the global north, whereby they've had decades and decades of discriminatory policing practices. And this discriminatory data is what has been used to train predictive policing systems. And so these biases are, of course, carried over into the algorithms. And so when making predictions about crime or potential criminal activity, the bias that was already present in the policing system is then carried over into the algorithms. And so it's the same thing. If we're training AI systems for use in ADR and there are historical biases in the data, then these biases are going to be amplified and replicated. So these systems, the standards that should be set should be that the systems should adhere to the principles of equity and impartiality. There should be human oversight. No AI system should be left to its own devices to make such critical decisions that affect people's lives by itself. And there should also be bias audits and fairness thresholds. So setting fairness thresholds in the systems allows us to interrogate whether or not the system is inherently fair or biased. And with bias audits, we can backwards propagate and investigate and see where exactly the bias is coming from or what can be done to eliminate the bias in the system. And finally, it's important to also choose the right type of machine learning algorithm. This goes to understanding the intended use case of the system or the fitness for purpose. So there are different types of machine learning algorithms that can be used to create your tool or your model. And each of these has its own strengths and weaknesses. For example, decision trees can be used to predict outcomes or explain decisions. They're good for classifications, but their weakness is that they can become a bit complex. We have neural networks or deep learning that are good for speech to text, image analysis, or language generation. They provide a lot of accuracy on complex data, but sometimes they have the challenge of being, they have the black box phenomenon, or they are very difficult to interpret. We have natural language processing, which can summarize things such as contracts or extract relevant information from documents. They're really good for text-heavy tasks, but they require very large data sets and can be context sensitive. We have reinforcement learning, which can assist with negotiation bots. It learns from interactions, but sometimes they can be unpredictable or difficult to control. So even when sourcing for the right tool to use, it's important to understand which machine learning algorithm it has been trained on or how the model has been created, because different algorithms are suitable for different tasks. And so without fitness for purpose, then the tool, you might spend a lot of money on the tool, but it's basically useless for what you want it to do.
Thank you for that. So a few key takeaways from me, just based on your conversation: be in a position to interrogate the rationale behind an output for a tool, test it against an known outcome, then setting fairness thresholds. I think that was my key takeaway from it. So allow me to write in Quency. What should ethical AI look like in arbitration? And are there specific red lines we must draw in its use? He has definitely hinted, Nelson has hinted on a few of them, but please further elucidate.
So I like Nelson's breakdown because I feel like not many people actually see the inner workings of how to train an AI. So since we don't have a framework, a centralized framework, I'll do it this way. I'll do what I normally term as AI alignment to other laws, so that you see how possibly this can work within the ADR domain. So what does ethics use or ethical usage look like? Ethical usage looks like this from the value chain. One, whenever you're onboarding a client to either a private arbitral matter or the institutional arbitral matter, the letters of engagement must disclose that you as an institution or an individual will rely on usage of an AI system. That is number one. Particularly, it's like having a privacy notice that indeed, whenever you enter this establishment, you'll be subjected to the terms and conditions in this establishment. It's something you need to disclose from the word go, because the lawyers and further arbitrators will have a field day with you out of this. It's meant to protect you as the vendor, the vendor of that particular service. And also it's meant to protect your client in case there's a decision which cannot be explained and it arises from utilization of that particular universal principles which are widely accepted, ethical values. So just a second, let me close it. Apologies for that. So We have ethical guidelines, and I always say, since we have a very decentralized framework, majority of the compliance or the AI champions in majority of offices will have to align with top-down kind of mechanism. One, we have our OECD AI principles, which, if you note from the year 2022, went from being 4 to being about 7 of them. All this is in tandem because we have different tests and we have different diverse data groups and data sets which are being used. For example, when it comes to the learning mechanisms for the AIs, it will depend on what stage you're on board in this particular system. So always start with the OECD principles. It's good. So if a system is transparent, what do you mean by transparent? If I align a particular ethical principle or maybe accountability and transparency, I will lean towards the data protection realm. And I will lean towards it because it falls in tandem with the data protection principles. And in this case, whenever you're onboarding a client, you get gathering their data. If they have signed off on, it's okay for you to utilize an AI system to analyze the particular information, well and done. Now, you get their data and you can subject it to an AI system. That's the first one, the AI principles, the data protection principles. Secondly, the right of an individual to refuse the information or the data from being processed by an automated individual decision-making system. Still in tandem with the Data Protection Act, it has to come out that consent is express. It doesn't matter at what stage you're using this particular AI system. If your client calls you when you're still doing an analysis of maybe the facts and you're trying to build a case for the arbitral tribunal to see that indeed in your application, this is what the client intimated to me and this is how I represented it. If the client withdraws before you submit, you have to halt. And this is because of the Data Protection Act. Additionally, look at the Kenya National Human Rights Commission Act. It does define bias, but bias also is not exactly limited to technology. Bias is inherent depending on the domain which you are leaning towards. And since we're leaning towards the tech and dispute resolution is a protected characteristics, which is codified in the Constitution, correct? Good. Once it's codified in the Constitution, you have to realize then it's not read in isolation, it's read holistically, which means the Kenya National Human Rights Commission Act, if memory serves me right, about Section 809, does define what bias is. And that bias, if you're litigating or if you're going back to arbitration, will define the precepts of how to define bias. The reason I insist on this is we have bias based on output, bias based on input, and bias based on processing. I'm drawing the whole map for everybody. Once you can be able to map all of this from the onset, then you can understand how the different pieces of legislation and the different processes will work, depending on whether your output goes your way or goes against you. That's done. Now, when it comes to now ethics, another aspect of ethics you have to realize is we have old computer laws or Computer Misuse and Cybercrimes Act, and it does prohibit a certain level, and I say this loosely because it was part of my research. It does prohibit a certain level of data abuse, meaning that if the data input or the data output in both cases is inherently biased from the word go, you as the you as the user of this AI system will have to have what you call library notes whenever you're training such a system. And I'm sure Nelson is aware of this. The moment you have notes as to what are the precepts or what are the boundaries within this bias is accepted, then the output will vary depending on this particular bias. If it is a black box mechanism, when you have a sort of bias mitigation protocol in terms of policy internally when you're training this data, it means that whatever black box processing that's happening in between, you can verify it by having this note somewhere, and it provides something we loosely term as a glass box mechanism, meaning we're trying to make it transparent as to how this particular machine renders a decision. Okay. Additionally, if I'm to lean back to data protection, Moses mentioned a DPIA. However, there's a limitation to the DPIA when it comes to AI systems, because a DPIA only covers a direct relationship between processing that information fastly for that particular purpose. Beyond that, you'll have to conduct another DPI. It's currently there's another webinar which is happening by another organization, to which one of the speakers and I had a good chat, and I was telling them the limitation of a DPIA when it comes to AI is that AI can process data to further connotations or to further levels beyond what the intended reason for a DPIA is. If you are to have, for example, a decision tree, and there are three levels of making decision. One, you're feeding this data and you're siphoning it so that it becomes readable, so that you feed it to another level of processing, another AI, it can be able to, one, collect data for maybe your arbitral clients, two, can tell you which one is high in terms of priority. It's just reading this data. What levels of information are you collecting? Are you collecting their names? Are you collecting their case number? Are you collecting the level of dispute resolution where they've reached? That is now how practically we bring out the whole transparency. And I know it's not as direct as people see, but if you look at the contrary, which I remember Nelson talking about predictive policing, I urge everyone to look at State versus Loomis. It's a New York case. To further just elaborate, there was a further opinion by one of the judges in that case, where you will find that the New York heat map was very biased. But by predictive policing in that case, what it meant was that they were trying to predict areas which have got high prevalence of crime. And the problem with this was that it was using only one metric of data. Which area has got most shootings or most killings? It does not subjectively have or factor in how areas people live in, the sources of income, the high mortality rates, where there are shops, where there are itinerant and formal employed workers. It did not factor on all this. If you had to collect all these data, this is one DPI after second, after third, after fourth, after fifth. And that is how, when you come to processing, the limitation of the DPIA is that if you are to do one overall DPIA, which would be necessary because of the human in the loop element, then it would undermine simply how the system thinks or how the system executes its function. Many professors have theorized that indeed, over a period of time, you will need to have a form of okay, let me be biased. I wrote on it, algorithmic impact assessments now, meaning we're not only looking at the data which is being fed, but we're looking at the algorithms in tandem. It's not a checklist. It's meant to evolve, because don't forget, from the initial example which I fed, State versus Loomis, Samantha, State versus Loomis. So if you check as to how the algorithm does evolve, and Nelson can attest to this, the moment you feed a particular system data, it can amend and it can create a further categories of further decision trees, which will be complicated in long term. That means the algorithm is changing over time. It's not static. The best case to look at this is the Canadian model, which after their act, it sort of collapsed because now companies were suffering from regulatory fatigue, because each and every moment they were complying, and it became a bottleneck rather than a boost when it came to them onboarding AI systems. Then, in alignment, we can talk about competition practices, and this is now how I'm going to bring it ethically. Most of them I have got the privilege of teaching and training guys on ICT law, and the one thing we've looked at are contracts. So this is how majority of ICT or AI contracts is: a vendor, a distributor, number of users, permissible use, and clauses of severability, use cases, and vitiation. Forgive my Luo nature. But the one thing most people don't realize is when it comes to alignment, in case there's a harm or an offense which has occurred, who do we assign liability to? Is it the end user or is it the vendor of the service? Currently, there is a lot of talk on the vendor, and this is why. Let me give a current example. We have ERP softwares. ERP softwares that are out here are meant to onboard a particular set of people, a particular number of people. If, for example, you as a procurement department are going to onboard a particular AI system, and it only allows for 25 people, it means you have to resubscribe to that particular vendor for them to now further enhance the package so that you on that were there with 25 people, that's the scale factor. This is a particularly problematic area because in terms of accountability, if you are in an organization of 20 people like a law, 50 people like a law firm, and one person prompt a system which is continuously learning, and that error is now put into the coded library of that particular LLM which is onboarded. It means that the variance in terms of error will precede and will follow every single prompt which all the users are privy to. That is now why we say we'll apportion blame to the vendor. The reason why I say this is when the vendor does disclose that this particular AI software is going to be beneficial to this, they're doing a pitch deck for you. But how does it align with the internal policies? Does it mean that there'll be good output? There'll be verifiable information, forensically traceable? And additional, will it mean that if I decide not to use this AI system, will it still bill me further? It's just organizing the chain in tandem with how particular ethics now is discharged in the river, leave alone the theoretical frameworks, where someone will tell you, oh, align with this, align with that. Now, lastly, which I think is very important, look at the PCB frameworks. We have about 9 PCB frameworks that deal with artificial intelligence. I'm also going to tell you about them, oil and dandy. The one thing you have to realize, which one is most appropriate for your organization? And it depends on the number of people you are particularly have in that organization. For example, most people will cry world over that AIMS, Artificial Intelligence Management System 42001 of 2022, is the best management PCB standard, but it doesn't apply to anyone. It's very expensive for you to particularly onboard a PCB standard with a low volume or low output kind of organization. Take for example, IT or cybersecurity systems are more appropriate for you. If you're an organization like a government institution with 10,000 people, then in terms of cost benefit analysis, it makes sense to do a PCB standard evaluation and to make sure that you have it there. If you look at this, it just forms part of ethics because it will box you into a form of compliance hole or compliance loophole, which will help you ethically comply and ethically use that particular issue. If there's a dispute, you have a redress mechanism. If you have an audit query, the IT or the ICT people are well endowed to particularly do this. If you have a legal issue which falls in the bracket of data protection and the legal precepts, you have documentation which is particularly important for you to trace. And it's quite important because as we are going further from, I think, really world over, more and more organizations are onboarding AI systems. It could be in the production line if you're in manufacturing. It could be in fleet management if you're in logistics. It could be in document management or tracing when it comes to the white collar sector. That is how I look at ethics. Thank you.
Thank you, Quency. So one of the things that I still have to pick a fight with you and have a conversation with you is the liability element. On a personal note, I strongly believe that there has to be some form of collective responsibility, but that's a conversation for another day. There are certain words that are being thrown here and there that might be unfamiliar to a lot of people. So Quincy, the next time, say everything in full so that we don't lose anyone. And because of this brotherhood that was made, I have been seeing a lot of this one will discuss this. So I am picking things. So far we have RAG system and library notes that Quincy has given or given the ball to Nelson to explain at some point. So Nelson, as you're addressing your next question, please feel free to address us on those specifics. So I'll go straight to Moses. How do we balance efficiency with the danger of over-reliance, and what safeguards or ethical practices should be non-negotiable?
Okay, all right. All right, I think Nelson had touched on the benefits of AI. Now, just to go through quickly, if you check the Chartered Institute of Arbitration guidelines on AI and also the Silicon Valley Mediation and Arbitration Center guidelines, the benefits of AI are many, so many. The most common one is efficiency and quality. There's legal research, there's data analysis, text generation, there's translation and interpretation, there's transcription of matters like hearings. And then the most important one major one is case analysis. Now, all those things are positive, and I won't deny that I'm a heavy user of these AI tools, especially right now. I use like 7 of them. There's Gemini, Grok, DeepSeek, Google LM. No, sorry, not Google LM. Then there's ChatGPT, then there's Grok. I use them on different issues or rather cases. But the one thing that I like about them is especially in terms of case analysis. Now, sometimes I'm a practitioner and you may find you have a mental block or something. But if you submit similar kinds of facts, of course, anonymized and also not mentioning any parties in specific, it can actually give you a different perspective of the case than you actually had thought of. That's a major bonus or rather positive. However, of course, every tool has its own advantages and disadvantages. And one of the disadvantages is actually coming to over-reliance on the same. Now, how to counter this? The answer is normally very simple. It's human supervision. And the reason I say this is because I've seen cases where I've actually had to even highlight to either the panel or the judge that some of the cases this other party is actually highlighting don't even exist. And how I noticed it is because how the submissions are drafted. There's a certain way which particular LLMs draft their own submissions, and actually you can actually tell from afar. It's public record. It's the case I was dealing with before the Public Procurement Board. It's actually Laser Insurance versus Nursing Council of Kenya. Now, it was submissions by a party where I actually found that the cases they're actually citing actually in support of my own case. So of course I'm curious. I go to the library for the public procurement decisions. I search the case number. Then when I go to the library, it actually contains totally different parties. So in the actual sense, that case doesn't even exist. So of course, in my submissions, because I want to win the case, obviously, it's a procurement matter, it's sensitive and it's time bound. Of course, I highlight to the board, they don't even consider the submissions by one particular party because they actually don't even exist. And actually, if you read the decision of the public procurement, they actually highlight the same issue because the board actually reminds litigants that your officers of the court, at the end of the day, your primary duty to the court is actually to uphold the truth based on what is there legally speaking. So you coming in and actually submitting fictitious cases, fictitious provisions of the law, which I can actually someone can tell that these actually were hallucinations by one particular AI model without actually basic verification is actually very wrong to parties, to even the court and also to the tribunal. So at the end of the day, the whole point of AI tools is at the end of the day, at the center of it all, it's you as a human individual. You have been trained 4 years, maybe 6 years, or even longer than that, to actually uh, distill issues, for example, in law, to assist parties to actually come to a resolution. But if you outsource your own thinking and also your own reasoning capacity to an AI model, which actually has been trained on maybe wrong particular kind of data, eventually basically abdicating your responsibility. And one thing I realized is I think the professional indemnity that lawyers do is actually going to change within the next, give it 5 years, because if people keep using this kind of tools, eventually some people, of course, will be lazy because maybe there's pressure of work. So insurance would be basically looking at our coverage only extend to these particular things. But if you use particular kind of models or AI tools which have no basic certification, eventually you're not going to be covered. And at the end of the day, the one who's going to be looking at the liability. And then one other issue I was being trained on, when I'm doing my course on cybersecurity is it's very difficult to create insurance on aspect of cybersecurity and AI. Because an aspect, and Quency mentioned it, is when you're looking at these software contracts, I negotiate for several of them. One aspect they always keep in that contract, and they'll never even bother to move, is the issue of limitation of liability. If something is to happen, how they normally capture it is this way. If something wrong is to happen when you're using this particular model or whether a software or anything, liability is limited to the last 12 months of your last payment. What does that mean? So let's say you pay me, let's say card every month. Something wrong is to happen. Let's say you give me something wrong, or maybe some data is misplaced, or like that. I can incur is actually the data which is leaked, or rather whatever happened which was wrong, you may have incurred deeper liability than that, and you can't take them anywhere. I was reading, if you read the book by Professor Millard on cloud computing law, when cloud providers actually provide services, they're normally tied to, they normally have this concept is, I can draft a standard contract to serve millions of people, or I can draft a contract to cater for you personally. So then they have to look at the numbers. I'm supplying 1 billion customers than you. Why should I create a special contract for you and neglect the others? So what they normally do, and when they are dealing with distributors, is there are certain things we can never negotiate. What you take it or leave it. So at the end of the day, so when it comes to now what safeguards you can do, at the end of the day, I'll just come to human supervision. There's no other simple answer than that. Yeah.
You can read something and just know that it's been AI generated very easily if you use these tools regularly. So we'll now switch the conversation to protection, both in legal safeguards and procedural integrity. This next round, which is our second last round, will focus on confidentiality, admissibility of AI process information, and the obligation we bear under the framework. That's finally so that everyone can get a break at some point. So Nelson, if you are here, yes, allow me to spotlight you. Done. So should evidence generated or processed by AI be treated in terms of what
our enemies. You remember some of the things that were told, some of the principles related to relevance, authenticity, reliability, and fairness. These are some of the core principles that govern the rules of evidence. So what we need on top of that, not as an aside from that, we still need to ensure that those principles are met and that AI-generated evidence is still held to the same standards, but also as an addition, we need extra scrutiny. And what this extra scrutiny does is to help us decide, number one, or rather, to help us look at number one, how the evidence was generated or processed. So this goes to authenticity and verification. Was the AI used to reconstruct missing or corrupted data? How do we know that this evidence that is being presented is authentic and has not? So there needs to be, this interrogation allows us, or rather the adjudicators, allows the adjudicators to understand what was done to the original data and whether this tool that has been used to make these modifications to data can be forensically validated. Number two is that it allows us to understand, or rather we need to interrogate whether the AI system is explainable and verifiable. We've talked extensively about the black box problem. And I've also seen a discussion in the chat about how to deal with the black box problem, and I think the response was very good. Perhaps the outputs that cannot be verified independently should be avoided, and that's 100%. I agree with that. So where there is no transparent reasoning provided by the system on its output, then it's not explainable and it will violate the right of the other party to contest, number one, and to cross-examine the evidence that has been presented by the other party. Then we also have, we also need to scrutinize and understand whether the parties and adjudicators understand and can challenge the evidence. We've already mentioned that as far as the opacity of the algorithm with the black box problem is concerned, and what biases, inaccuracies, or alterations may exist. So we've discussed how AI tools that are trained on biased data may reflect or amplify the discriminatory patterns and characteristics, even if it could be unintentional. Moses also mentioned something about chain of custody and data integrity. When AI tools modify or reconstruct inputs, there are questions that are raised about what exactly was changed and whether it can be traced. This is what I mentioned about audit trails. Are there enough audit trails to be able to independently audit this data? Can you produce a timeline of the data transformation and explain that transformation itself? And so without a digital chain of custody, then the trust in the evidence obviously collapses. We also need to understand evidentiary weight and admissibility. If AI-generated evidence is admitted, how much weight should it carry? Should, if we've perhaps generated a video, should it carry the same weight as original footage? So this essentially goes to, is more or less a governance problem. And what I find that works in such situations is practice guidelines. The challenge that we have with technology is that the pace of technology outpaces legislative developments. And so because we cannot legislate and govern at the same pace that technology evolves, then practice guidelines are usually a very good way to fill in the gap in the interim. And there is also usually the challenge of innovation and governance. What I find that works best is that it's good to work from policy and go then towards governance, because with policy, policy offers a strategic vision. So that's 5 to 10 years in the future. We are drafting policies to tell us where we're going to be 5 or 10 years into the future. And with that vision in mind, understanding where we want to go, what we want the tools to be able to do, what are the applications, the use cases, then we can govern around that in such a way that we are not stifling innovation. And so the best practice is usually to offer practice guidelines and wait for the legislative arm to catch up. And so what solutions or safeguards need to be put in place for AI-generated evidence? There needs to be disclosure obligations where evidence is AI-generated or has been passed through some kind of filter or editor that is AI-based. There needs to be independent expert review, so whether that's paneling of, let's say, a board of experts that can be called upon by the institution to review. There needs to be explainability requirements or standards, chain of custody protocols, and weighting rules to evaluate the property and value of AI-generated evidence. You had asked me about RAG. I don't know if we should cover it right now or in the next question?
I think in the next one, so that we don't lose the flow.
Okay.
You've set this, you've literally set the standard for Quency to just come directly in and now introduce the regulatory framework. So basically now, to Quency, how should regulatory frameworks, both local and global, evolve to support fair and transparent AI using arbitration? He's definitely touched a bit on it, but there's something you mentioned yesterday in our debrief about, is it the Savannah?
Silicon Valley.
Sorry, the Silicon Valley. I'm in Africa, so I think like an African. So the Silicon Valley. So please further expound for us based on the question.
Okay, so like I said, we have a disaggregated framework. Here's the thing. Everyone says AI is a collection. Sorry, everyone says AI is a machine or a system that makes decision close to humans without human intervention. So this is the twist when it comes to now defining the regulatory framework or possible regulatory framework. Many legal authors over you could take a look at Cummins and Malgary. They're some of the best authors when it comes to AI and regulations and ethical conversations. They do term it as a collection of other technologies. And it helps currently with how the world over is struggling to come up with a central regulatory framework. So when it comes to now in particular, let's now narrow it down to arbitration. Depending on whether you are going via an institute or private practice will determine what route you're going to take. If you're going to take a private practice where you are an independent arbitrator, then you need to be subjected to legal frameworks. The Silicon Valley mediation arbitration laws are a good place to begin because they do talk about technology use cases when it comes to mediation and arbitration, and they do provide boundaries within which to operate, particularly when it comes to dispute resolution. I think it's good because when a final arbitral award is challenged on the basis of transparency, then it raises the question, did you have disclosure requirements as to using these automated systems or AI? I always look at it this way. When you are told to have discretion and you're discharging a duty, you are supposed to use your own human cognition. Hence, your synapses need to fire and you need to make a decision. If you are subjecting it or if you are procuring now another brain or artificial brain now, if I was to loosely say that, you need to disclose this because the skill which is bestowed upon you as an arbitrator is based off of your own cognition. Now, the reason why I rope this in is because if you're going to use if you're going to use an AI into arbitration, there are few factors which you're going to delegate. Most people are guilty of this. Final decision making, you're going to surrender that to that system. Logic, you're going to negate to that system. And those are protected characteristics under human rights, which are not supposed to be delegated because they form a foundation for majority of laws or regulations or rules which govern the adoption, use case, and rollout of these systems. Now, if you're an institution, the arbitral institutional guidelines, which they're good, but as Nelson has said, policy, then we move towards governance. To me, it's framed like a policy. It's very general. Use cases will depend on one, the arbitrator or the arbitrator within the tribunal, and then the arbitrators who are now in charge of this particular argument. My proposal in various fora and various papers, which I'm still writing, is always have sectoral guidance notes, which factor in these three actors as a whole. Because the rules for an arbitrator being the head of that particular tribunal will be slightly varied depending on the years of experience and also depending on the use case, because they can use AI for something as simple as document analysis. That is very innocent, but after the fact, after analyzing the documentation using this AI, do they go back and check on the on the reasonings of those particular AIs, especially if you use a deep learning models like the one in DeepSeek, where it shows you the considerations it's using. Secondly, for the arbitrators now, the disputants now seek redress, they need to be limited because now they're discharging their obligations professionally as arbitrators before tribunal. And they need to, one, disclose either whether they're going to process the entire documentations filed before the tribunal using an AI, that's one. Two, whether they're going to file their submissions using that particular system. Or three, whether they are going to fully adopt an AI system where it tells them everything to do from the word go. And I remember from our conversation yesterday when we were doing our preliminaries, Moses did intimate how ChatGPT can create a learning profile, and then you can feed it documentation and it can learn. So that is something that the arbitrators in the tribunal need to disclose. So if there's sectorial guidance notes on arbitration, that is where we begin. Now, for private arbitrators, it's going to be eerily complicated for you because not only will you have to face the commercial law legislation, but you'll also have to figure out small pieces of legislation and regulation, such as your professional association, which you belong to. I am aware that majority of arbitrators don't only belong to the legal profession, but you have architects, you have doctors, you have engineers who come from world over. Their institutional rules ordinarily will have to have a form of guidance or policy on use cases of it. Not only will they have to adhere to this as a framework, but they'll also have to adhere to external frameworks. So there will be an internal and external framework. Now, after that, as you said, insurance is a very, 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 very tricky business. Ask yourself this as an arbitrator in private capacity. If the decision rendered by that AI system falls outside the scope of professional indemnity that you have, how will you recover from such an act or an omission? And it's very good to be cognizant of this because I wish I could remember that particular case, but the decision was in the revoking of that particular arbitral award. The bench did opine that in case the fiduciary duty or the fiduciary map is violated by the person who has a higher duty of care, then it is the liability in absolute does remain on them, in particular as an individual, because one, the ignorance as a whole will not be used as an excuse in this court. Two, they ought to have known the risks and known the limitations of the particular indemnity. So as a framework, that is somewhere where they need to start thinking. So to summarize, for private actors, because for institution, it's a bit straightforward. Constitution down to sectorial laws, even it's the National Construction Authority Act, the policy internally, and then the guidance notes. If we're now talking now regionally now or world over, there's a question which the clerk of the Senate did ask us when we were doing our trainings a couple of months ago. Which one precedes the other? Is it policy or strategy? And it's a question I will pose to the audience. I won't answer it for you because that then will map whether having a strategy is prudent and then falling into policy and then falling into regional economic bloc agreements, and then it granulates into a national image. But that is just how it trickles, because in Africa we have the AI content strategy, Malabo Convention, which on cybersecurity, which will form of suggest it's not exactly binding, and then we'll have now regional agreements. For example, the current conversation on cross-border data flow is a very contentious one, and this is how I link it. If you are hosting the servers of that particular AI system in Uganda, and there is a forensic audit that needs to verify that indeed this prompt is what happened, do we have an agreement between or adequacy between Uganda and Kenya that does pay into that? If I'm doing an audit, I can request the ODPC for Uganda to give me this following metadata so that my forensic analysts can. Anyway, that is cyberspace law. That is now we have to look at other regulations and other laws. So having a decentralized framework is very confusing currently, but if it's anything to go by what our global north partners are undergoing, I think it's better. Because currently there was a contentious conversation on reviewing the EU AI Act for it being too strict. I mean, for everyone in the chat, take a look at the risk classification in the EU AI Act and ask yourself this: what is the technical and the legal definitions of these particular provisions? It's a really important conversation because it might tell you where an AI assisting in arbitration will fall, and if indeed that particular definition is prudent or it's just descriptive in nature. Thank you.
Thank you, Quency. Which one precedes the other? Strategy or policy? Thank you. We move to Moses. With the amount of information that we feed into these platforms, how can confidentiality be preserved when data is processed by external or cloud-based AI tools? What best practices are emerging?
Okay. In terms of best practices, I think first of all, it's what I've seen is mostly use of systems which actually ensure the data which is submitted to them to the various platforms actually encrypted. Because at the end of the day, confidentiality can be known by any other party. And if you read most contracts, one of the not publicly available. So the systems that I've seen in terms of like case management, there's some case management portals which actually ensure that if you're going to submit the data to that particular institution or that particular tribunal, it has to be encrypted before you send it out. And the only way that they can access it is you actually send a code to the other side. Now, I think that's the major one. I'm yet to see any other way of preserving confidentiality, but the most common one is mostly encryption. That's the one I've seen.
Okay. So in the interest of us having a plenary session, we shall keep the last to at least 3 minutes each, just so a few of our audience members react to our conversation. Look ahead. So how do we ensure that AI in arbitration doesn't just reflect global trends as we discussed it, but also serves local reality and cultural context? So as usual, that's something else. And my question to you in respect of this is, what one innovation or practice would you like to see institutionalized in arbitration rules or infrastructure?
So I think the one thing I'd like to see, and perhaps it's not just limited to arbitration, is an AI audit infrastructure. We've already covered the importance of explainability and the need for audit trails, but it's not possible without an audit infrastructure. So what does this look like? It's, of course, up to the governing bodies, be they for institutional arbitration bodies or for our profession like the Law Society, to number one, empanel a group of certified forensic AI experts. These people can come in as experts during trial or during the dispute resolution process to offer guidance, to do things like the adjudicators. Number two is a registry of approved and audited AI tools for use in our cases in ADR. So the governing body once again comes in, gives you a list of tools that they have audited, they have gone through and they have seen are fit for purpose and can and fit well within the standards that they have set, especially for the audit infrastructure. And number 3 is standard protocol for evaluating algorithmic fairness, explainability, and data provenance. So what this does is set a standard, a universal standard that acts as a guide for all the individuals taking part in this dispute resolution process. And finally is a guidance on how to assign evidentiary weight to AI-generated content. So it's difficult for an individual practitioner to assign this weight by themselves. But if the institution comes in and the governing body comes in and offers guidance, practice guidelines or guidance on how to assign evidentiary weight, then it's a universal standard that can be applied for each and every single member of the institution. And this is especially important because it allows the adjudicators to weigh it allows the individual adjudicators to figure out how they should weigh the AI-generated content, especially where the system lacks explainability, where there's a risk of bias, or where there is no human in the loop.
Thank you, Nelson. To Quency, how do you ensure that AI used in ADR, basically whether it's arbitration, mediation, conciliation, and the like, reflects African context, values, and legal systems?
My friend Maya Juin would be proud of what I'm about to say. I know everybody chimes about Ubuntu being the ethical framework that everyone used to, but the one thing I've always advocated for is have regionally tailor-made ethical frameworks factored into every AI that they churn, because AI is not like a central. It's a term, yes, but now the tools that are coming out, they need to tweak them according to those frameworks. And this is why I insist on, culturally speaking, we are very rich and very diverse. Even in Dr. Melisomino's paper with Cecilia Bungo on indigenous knowledge, the data sets are so rich that we need to have a form of let me call them a form of framework to compensate people for allowing that data to be used to train. So if we factor in ethical frameworks, for example, in West Africa, we have Terangaza. In, I believe West Africa, it's called TWI. Then Terangaza now is a framework, an ethical framework now within the Southwestern Africa bit. You will find that it more embodies their particular system. And if, for example, you're using an AI in a simple community mediation and the Terangaza maxims and the principles are there, it works okay. I'm not saying perfect. It works okay. Secondly, as Nelson had said, we need a standard for ourselves, because if there's a standard algorithmic lever that can be pulled anytime there's a form of ill or harm that has been occasioned or is being amplified, then it's a possible framework for us to consider recompense whenever there's an irregularity or illegality. Lastly, I think I'll go the China way, and it's very controversial, but I always like it. Have an AI registry. I like how China is doing an algorithmic registry where it doesn't matter what you're building, you have to register it with a central authority. My proposal was to do it maybe with the DPC, if they could add like another, commissioner, or like have like 3 data commissioners within one organization, and then one focused on technology, data, the other on ethics. But it's just my rough thinking. Yeah, that is how I did. But Nelson's is absolutely like all-rounded, how we termed it all. Thank you.
Thank you. I like the way you got a surge of excitement at the thought of the question, but thank you for answering it holistically. And also, I've just realized in this entire conversation, you've all been complimenting what each one of you has been saying, which is it means that we are progressive and you're moving towards the right direction. Lastly, what does the ideal digital arbitration platform of the future look like in terms of ethics, security, and usability?
An ideal. When I was thinking about this question, of course, there are the common answers, which is basically privacy by design. When AI system is being developed, privacy is fundamental. I think if people who do CIPP I think it's called E, that's targeted to mostly to developers. I believe so, if I'm not wrong. When the basic concept is when you start developing a particular software or anything, the fundamental issue is that privacy has to be one of the core tenets. It's not supposed to be coming at the tail end. So that when you're developing this system, you actually take it back to your mind that indeed we are actually meeting the core principles of data protection and security. The other aspects is the other things which Quency and Nelson touched on is ethical use of AI in terms of how it's actually being used. And then the other aspect is actually usability and ease of use. And the reason I say this is because the conversation is the general conversation is that AI is going to replace us. And the other argument to that is that people who actually know how to use AI are the ones who are actually going to replace you. It may be your desk mate or even your classmate or someone who's just connected to you in some capacity. If he is able to use the AI system to actually do better work and in more efficient terms, he's definitely going to replace you. As an employer, if I get someone who knows how to use an AI system and is able to generate documents, something which could have taken a week is being done in like a day or even hours, who am I going to employ at the end of the day? And then the other aspect to it is your clients themselves. They know that this call to some or a sale agreement used to take like 4 or 5 days to be drafted. But if that same thing can be done in one day or in an hour also, who are they going to give the work at the end of the day? So, in terms of the ideal AI system, one thing, although it's controversial, I always think it's advanced analytics. And the reason I say this is because look at how, like, for example, Kenya law, how it's structured. It's the way it's currently structured is actually can even classify what kind of decisions were made by this particular judge, but it hasn't gotten to the level where you can actually forum shop for a particular, if let's say you're appearing before, let's say let's say Mugambi or who else, Mongare or someone. If the AI system can actually tell you when she is approached with a particular issue and uh, how is she likely to roll. So you'll be keen to know if my case goes to before her and given my particular set of facts, if she goes before, I'll probably lose. And the AI analytics can actually tell you that's the situation. Then it'll be more preferable even to file an application for transfer of the file to someone else. If that AI system can actually tell you this is how it rules and it actually gives you back the data and how she actually thinks. Of course, this thing was banned in some countries like France. In the year 2019, this thing was banned because people are actually realizing, let me forum shop, let me look for a favorable adjudicator or a favorable judge. But to me, I think it's going to get there eventually. And I'm hoping Kenya law will actually give access to these AI systems to actually give advanced analytics or given advanced reasoning based on Kenyan context. Of course, it's controversial, but sometimes I always like to see what's the worst that can happen.
Well, and now I'd like to ambush you because I can see we are okay in terms of time. For the plenary session, anyone who would like to ask a question, please feel free to raise your hand. I will call on you to ask the question. But today, I would like to ambush this fine gentleman of mine. So I have two questions for you as you. So I trust that we're ready. So as we wrap up this very interesting, layered, and forward-looking discussion of ours, I'd like to invite us to answer two very powerful questions. So the first one is, what should arbitrators start doing to prepare for this AI-driven future? And the second one is, what part of the arbitration process must always remain human? Is it the decision-making bit? Is it the document review bit? You've alluded to so many things. So I would love and appreciate it if each one of you is to give us their version of this, an answer to their version of this question. I will start as usual with Nelson. Do I need to repeat the question or we are good?
No, I'm good.
Please note an ambush. So to the audience, these are I hadn't shared with them, but I'd really want to hear their take on it. And please do your closing remarks.
Okay, so as far as what needs to happen to prepare for this AI-intensive workplace, I think it's always good to upskill yourself. It's good to stay at the forefront of what is being innovated, what is happening, what new developments are coming up. Like I said before, I like to think of AI as sort of Schrodinger's cat. You don't know if it's alive or dead. You don't know if it's good or bad until you actually get to use it. So always upskilling yourself, always being curious to learn and to understand, to see what it can do for you, whether it works for you, and where it can plug in into the workflows that you already have in place. Because, I mean, of course, technology advances at a very rapid pace. What perhaps was cutting edge last year is out of date this year. And so you always need to maintain that curiosity mindset. And I think that is the best way to prepare. You've asked what should remain human in the ADR process, and I think you've already mentioned it. It has to be the decision, because I think something that I always like to say is that we should not leave decisions that will have an impact on somebody's life to a machine. A machine cannot make some human considerations that we can. A machine is not capable of empathy. The machine is not, sometimes perhaps not able to see the full picture in the same way that you would as a human being. So in as much as we can rely on these systems in decision support, I think at the end of the day, the decision making should always, the final decision with the arbitral award should always remain with a human being.
Quincy, you can just jump right in, then followed by Moses.
Okay. Upskilling, as Nelson has said, is very important. I think as arbitrators, they have the power of curating a list of tools which can be used, which conform to the arbitral rules, any laws, any regulations that might injure their reputation, the reputation of the institute, and their output in general. What should remain sacred? Client interviews, don't outsource that. The actual defense or the actual representation is still very important. Document analysis is something you can really get to. The AI, but it has to have verifiable precepts. Okay, so there's one thing I forgot to explain. Human in the loop is an actual process. It's not just a one-off where you get to glance and then it. So there is a stage where just from an untechnical capacity, the arbitrators will have to look at the reasoning of that particular AI system, whether it meets their required output as to how they were trained. And then the output also needs to be verified. So it's like a human on the loop and human in the loop. On the loop from checking input and output, in the loop meaning the reasoning in between you feeding the data and it rendering the decision. Then lastly, the final award, or like the giving of the award of the decision, must utterly remain a human factor. Machines cannot think subjectively. They are always objective. For the lawyers in the forum, you can always look at it from the angle of always having custodial sentences. Someone murdered their husband, and objectively, the machine would tell you murder. life imprisonment. But if you look at the strenuous circumstances subjectively, it's something a machine can factor. My parting shot, embrace technology. I am starting to train people on AI governance, safety, and policy very soon. Keep a watch out on LinkedIn. I will definitely post a forum as to which I'll start upskilling people. The first 2 cohorts are going to be free because I want to test how much I can train people for 6 weeks constant. And don't forget to subscribe and be a member of the Chartered Institute. That is a must. Thank you.
Moses, you can just jump right in.
Oh, okay. Okay. In terms of the first question, I think in terms of how arbitrators can approach this technology, I think, in my honest assessment, it's a question of just being knowledgeable about the area, because one way or the other it's going to affect you. And if I may just give you an example, when I started doing ICT contracts, I was never trained on these things when I was in law school. I just learned it on the job. And the one thing I come to realize is the LLMs and the various AI tools have clearly just leveled the playing field. You might know nothing about an area, but just start using it. It will guide you what to look for, what to isolate, and in a particular circumstance, what exactly is the other counterparty looking at. I was doing another contract. I was telling Quency one time. I was invited to Huawei's office. My client is purchasing equipment from China to come and supply to one of our it's called what communications company. Now I knew nothing about the area, of course, but now when you go to these meetings, of course you can't say I may don't know, please, because you're looking at the end of the day, it's a job and you have to actually look at these issues being raised and try and understand them, then try and apply them. So you just try and use the AI systems to learn and apply it to whatever you're trying to do. So in terms of what should remain human, I think it's been touched on. I really don't have any additional points to say. It's basically reasoning and also our writing and also the issue of empathy. If I remember my contract law and trusts, I think the whole concept of equity came into being because even though you may be technically right, the circumstances in which your particular facts of this case are, if you just apply the law as it is, it will result into an unfavorable situation or unfair situation. And that's why how equity was born. And that's why like principles of injunctions came into being based on the facts. So at the end of the day, what should remain human is reasoning, empathy, and also the final decision that you're making is based on the facts and the law. At the end of the day, that should remain human, coming to the last decision. Yeah. And my parting shot is embrace the future. Things are changing fast. Yeah.
Thank you so much, gentlemen, and thank you for taking time to be with us today. I'm not releasing you yet, but I just want to say for the debrief, for the session itself today, I'm very grateful, and also just for expanding our mindset on this particular topic, because it's something we joke about, but it's something a lot of us probably even over rely on, but it's not something we really get to sit down and criticize and get into the specifics of it. So I'm grateful for you taking time. Also, I keep on saying, these are people I see regularly. So for those who are not part of the membership of Chartered Institute Arbitrators, kindly register. It is a platform that you need to be part of to enjoy such conversations and also to get to understand all these different forms of ADR and practice them. With that, I'd like to open the plenary session, but even as I'm opening the plenary session, I'd like to give a heads up to acknowledge that at some point, our YMG chair was present, David Onsare, but he had to log off at some point. Then there's Samantha Masengeli, our vice chairperson for YMG, who's present, and I'd really appreciate if she gives the closing remarks as we are coming to an end. But with that, I was expecting to have questions, hands raised, because we'd really love to hear your voices. We've been talking for the past 1 hour, 45 minutes or so. It would be lovely to hear some of your voices. So kindly, if you have a question, raise your hand, but I would still go to the chat section for the questions that were raised. I know a few of them were probably answered, but I'll ask them as is. Is there any hope or certainty that AI tools will level the playing field for under-resourced parties? This question was by Joanne Nelima. Moses, Quency, and Nelson, please be on the standby to answer any of these questions, and in no particular order. So whoever feels called to answer the question, shoots. Then Quincy, you were asked to read out but you already read it out. That was the Loomis case. Then the Isabel Nafuna asks, how should law schools and training institutions prepare future arbitrators for a tech-driven future? That's a great question. Our vice chairperson congratulates us for a great presentation. Then Maria asked, though I know it was answered, but for the benefit of those on the platform, how do we deal with the black box problem in relation to parties to an arbitration who may not understand AI and its algorithms to ensure they are satisfied with the arbitration process and ultimately the arbitration award? Nelson had answered it, and equally Joanne. Perhaps outputs that can be verified independently should be avoided, but Nelson had answered it. But feel free to go into it and answer the same. Then Joanne further goes to state some benefits of AI appear more realistic than others. For example, in data analysis, evidence review, legal research is already a norm, and it's benefiting in terms of efficiency and quality of the process. However, use of it in text generation, translation, and transcription currently, the offerings are not sufficiently accurate to be relied on, especially in arbitration contexts where accuracy is vital. Also, while AI-powered tools exist to verify authenticity of documents and maybe detect deepfakes, their tech is evolving and effectiveness varies. Perhaps arbitrators should use them as supplementary aids rather than definitive proof. I personally agree. So with that, allow me to render it back to, please feel free to raise your question. Let me raise your hand so that we can call out your name, you ask your question. But back to you, gentlemen, in any particular order.
Okay, let me take the question on is there any hope or certainty that AI tools will level the playing field for under-resourced parties? I think I can take that one and the one about law schools. Is there any hope and certainty that AI tools will level the playing field for under-resourced parties? Ideally, the answer should be yes. But technology does not exist in vacuum, and one of the biggest challenges that we have, especially with innovation in the justice sector, is the digital divide. That is this phenomenon where those in urban areas or developed areas or countries are more likely to enjoy the benefits of technology as opposed to those in rural or less developed areas. And so there is this risk of exacerbating the inequality that already exists if technological advancements are not also accompanied by investment in technical infrastructure. Then all these benefits that should ideally be gained from innovations such as artificial intelligence and other tools for the justice sector will not be realized, because it's one thing to have, for example, a premium subscription to ChatGPT, but it's another thing to not be able to log into ChatGPT reliably because you have a poor internet connection. So the answer is ideally yes, we should be enjoying these benefits, but innovation has to be followed by investment in the technical infrastructure. Without proper technical infrastructure, we're just going to exacerbate the digital divide, and inequality is going to persist, and those rural areas are going to be negatively affected and not enjoy the benefits of innovation in the justice sector. Then on the next question, for how law schools and training institutions prepare future arbitrators for tech-driven future. I think this is a function of upskilling. we cannot bury our heads in the sand and ignore technology anymore. And so my opinion is that it needs to be a part of the curriculum, and I would give a lot of credit to the Kenya School of Law, especially because I have actively seen and been involved in their initiatives to upskill not only advocate trainees, but also their staff and also the pupil masters that they interact with. So I think that's a very good start. You're upskilling not just the students who are coming into the market, but also the people who are already in the market who will be overseeing or supervising or training these future arbitrators and these future lawyers.
Thank you, Nelson. Quency, what's this?
I don't know which question in particular I should answer. I think I can touch on the training in law schools. Okay. One thing I've become to realize is when we are like for our law firm, is the one thing that you need to be trained on is use of basic AI prompting, because there are certain things due to how fast-paced the AI is moving, you need to be basically you have to know this. Because look, I'm facing pressure to deliver on work. I have limited time to actually train you. And the best train actually right now I can actually foresee is actually going to be the AI tools, because they know exactly how I like doing things. So like let me give you an example. When in like in ChatGPT, there's something called projects. In projects, you create basically like an entire system where you create like how exactly Moses likes doing their emails or letters or correspondences or submissions. There's a structure like the structure is basically what I use in my very course of everyday life. So when someone comes like a new pupil or an intern, I just take him through. This is how I like doing it. Test the system out. If you have any questions, just ask me. Because when I'm sending you work to do, this is something you have to take into consideration. Because I'm facing pressure to deliver on certain files. So getting time to actually train is going to be actually very, very little actually. So what students and law schools need to train is actually you have to know how to use the systems. Because it reached a point where when the people are actually looking to hire, the first question will be, do you know how to use this as a particular kind of system? Show me. It's not going to be law questions. It's going to be show me how you actually approach this thing using the AI system. And then I think that there's someone who had raised an issue of transcription. I think the problem with transcription, I've come to realize when I'm doing arbitrations, is the local dialect does not translate easily to the AI system developed in the Western world. And some companies in Africa have actually started coming to localize our language, because our language has different kind of accent and tonalities. One example I can give you is a company in Zimbabwe. It's called Vambo AI. It actually understands the local context of a particular language. It may be English, Kenyan English, Kenyan Swahili, or even local languages like Kikuyu, Luo, Kalenjin. They are actually developing AI systems to actually understand, and actually you can be trained on local language using that particular AI system. So it's now up to such kind of technology to be incorporated in terms of ADR, so as to be able to transcribe easily. Because sometimes Kenyans, and I'm also guilty of it, we sometimes interchange words because we are most of us at a basic minimum, we speak a minimum of 2 languages. Some speak 3 because of their mother tongue. Some even speak more because of international experience. Now, what I've learned is the more languages you learn, the more you're thinking, how you think and how you speak actually changes.
Thank you, Moses. Quincy, do you have anything to comment?
Yes, I've seen Lewis's question, which is it's a brilliant question, to be honest. So yes, within the Hiroshima process back in 2022, there's something called the Universal Guidelines on AI. So it kind of gives like the universal rules or the set of rules which will govern any AI or robotics technology which is churned out. They have principles such as do not harm, do not supersede your master. There are about 12 rules. Take a look at them. They will really help. The question on deepfakes, oof, I'm having trouble with even coming up with legislation on this because it's something which I am actively working on. I do like the whole capacity of using AI not as a deterrent, but as a way to enhance or sort of to bring alive some certain aspects of document review or evidence within courts. But the primary motive ought to be if by then I give this to the entire chat or the entire room. If there is a legislation which needs amendment and you have an idea of how to amend it, bring it to me. We sit down, we have a chat. Currently, I'm trying to amend like 6 pieces of legislation. It's not exactly easy to factor in technology alone. The one for deepfakes is very useful. Now, for literacy skills, particularly when it comes to Kenya School of Law and majority of campus, I think we need to expand the technology law domain because we have ICT law, we have data protection, we have esports, we have blockchain, we have AI. All this needs to be taught individual as subspecializations from campus. And if now when it comes to now real life application, KSL, even if we introduce a 10th P for everyone, let's have like something of a unit or a subspecialization within a particular unit where people are actually exposed to these tools from the word go. Thank you.
I think I should add something on Quency or rather a question.
Yeah.
I know my question is always, well, is regulation really necessary at this point in time with this technology?
He who
Because
pays the piper plays the tune.
the reason I say this is Kenya, I don't know if it's the same, I think in terms of Africa, whenever a nascent technology comes in, the first point of call is to regulate it. You never actually let it breathe. And my argument is always this. If I look at the Singaporean policy on AI, the focus is more on building capacity. They don't follow a governance approach. They follow a more infrastructure,
Innovative.
training, and innovation. They focus on actually developing the technology before they actually come to actually regulating it. And my argument is Kenya's approach wrong, or is it just how Kenyans do it? You regulate first, then you ask questions later.
Colonially speaking, we have always gone the risk-based approach in the majority of all our regulations. It just stems from how we relate with colonial legacies and insurgencies. I do agree. Like my divergent capacity does agree. We don't need to overregulate because it's part of my series of articles which I wrote extensively on regarding which approach should we take on regulating AI. Is it liberal? Is it risk-based? Is it freelance? What should we take? And I do give case scenarios. Look it up on internet. But I do agree, Moses. However, he who pays the piper plays the tune. I'm just following instruction.
Okay.
Yeah.
So this will be continued over the cup of coffee. But with that, gentlemen, again, thank you for gracing us with your presence and for the intellectually stimulating conversation that has turned Moses into a very nice moderator. And I'm loving the fact that as we're having these conversations, a conversation that you're so deeply entrenched in, that every question, I can see light bulb moments just shooting up on your heads. So thank you for your time. Thank you for your insights. And I hope to the Chartered Institute that this is the first of many, because clearly there's so much more we need to explore on this. And to Moses, at least Moses, I read a lot of his articles. Now I get to Quincy, I'm hoping to be part of your first cohort training. So I have already, yes, I'm manifesting to the world. So be on the lookout for that. And to Nelson, thank you so much for your time. With Nelson, I think this is the second platform we're together on. I look forward to more. Before we leave the session, if Samantha is on call, Miss Samantha Masengeli, our vice chairperson at the Young Members Group, there's so much going behind the scenes, and they're working through the night to try and ensure that we have multiple activities. So I'd like to invite her to close the session and also tell us if there are any announcement in respect of the Institute. But to my audience, thank you for your time. Thank you for staying till the last minutes. Ms. Samantha Mesengeli, to you.
Karen, that was an ambush. To everyone else, good afternoon. I think good evening. It's such a pleasure to see so many of us in attendance. Particularly AI in ADR is a subject that is very close to my heart. And interacting with this gentleman has always been a very interesting. You learn something new every time, and at every conversation. I have interacted with Moses and Quency before. I think I'm now getting to know Nelson. We will surely have a cup of coffee maybe sometime soon. Yeah. So thank you all for this time. It was a very entertaining, interesting, and educative conversation. Next time, though, when you're giving us these words, especially for those who don't know, please try and like instead of giving it in abbreviations, give the whole, especially for Quency. I thought Moses was trying. Quency was just flowing with it. Yeah, so you might say Didi, and Didi means something else to someone else. So in this space, yeah, let's try and do that. But overall, it was a very enjoyable session. Thank you. And Karen, the moderation was very well done. And we could actually see there was a lot of planning that went into this in prior sessions. So well done. So for now, since it was an ambush, I probably just have one or two events that I can say are coming up with the Institute. Currently, we are doing, I think, introduction to arbitration for those who are new to this space. And as you've been told, join the Institute. There is so much that it has to offer. So we are having introduction to arbitration that is going on. And then after this, we will also have our conference that is coming up. That is in November. So that is the other major event that we are looking forward to. We are inviting you to please attend, and definitely there is a whole panel topic that will be dedicated to AI and ADR, and you will probably be seeing the very same people that you have seen here on that panel. So we look forward to having you. It's from the 17th to the 21st of November. So I think communication is already out on different platforms. Please be sure to register and join us. So otherwise, I would want to wish you a pleasant evening. It has been a good 2 hours, and we don't want to extend it any further. So asanteni sana, and have a good evening. Thank you.
Thank you.